SJC-13092, Commonwealth v. Marek J. Kozubal.
Okay, Attorney Nathanson.
Good morning, Your Honor. May it please the Court. David Nathanson for Marek Kozubal. Today I'm going to focus on arguments 1 and 2, hoping to roughly equally divide my time between those questions, but I'm happy to answer any questions regarding the other issues. I'm just jumping right into it. The jury selection issue, setting the stage, the trial judge sua sponte disallowed trial counsel's peremptory challenge to a quote-unquote minority juror. And as a result, the trial judge erred at each step in the resulting bats and swords analysis as a matter of law. Whatever discretion judges have in the bats and swords analysis, it does not extend to legal error. And here, quote unquote minority, is not a cognizable category under that rubric. This court has repeatedly held that person of color is not a category under bats and swords. That's, Ortega, Jackson, Prunty. Here, the category that was articulated is even broader than that, which is minority, so that it encompasses not just race, but ethnicity, religion, gender.
Attorney Nathanson, weren't both of the jurors who were challenged African American or black?
I missed the very first few words of your Honor.
Weren't the jurors who were challenged black?
So here's the state of the record, Your Honor. At the time the trial counsel is asked to articulate their reasons for the strike, there's nothing in the record. After trial, the judge says, maybe the juror was black, maybe the juror was black Hispanic. So that's post-trial information. I agree actually with the Commonwealth that post-trial information and post-trial additions to the record about this are not proper. Defense counsel wants to say, well, he was also applying to be a police officer, blah, blah, blah. I agree, that shouldn't come in. I also agree that these post-trial characterizations are not relevant, but even if that's the case, that's not what trial counsel was asked to respond to, right? We could have, for example, a black woman juror who's objected to, right? And the category is articulated as minority, right? But at that point, trial counsel doesn't know what they're supposed to be directing their responses to when the judge
Mr. Nixon, I'm a bit confused. I don't know if you answered the Chief's question. The first two jurors were articulated as African-American, correct?
No, they weren't. There was no articulation at trial, during trial.
I think what the problem is that the lawyers and the judge are seeing some person in front of them and they're using general language when perhaps, as you argue, more precision was allowed, but such that the defense attorney doesn't even say anything about it.
Right.
Yeah.
There's no argument that the person is, what you can infer, a person of color.
But that's not enough, Your Honor. And so the first thing I would say is, so for example, in Justice Kafker's opinion in Jackson, the court points out, well, we really need you to clarify, and so if the judge had, like the judge in Jackson, interjected and said, what do you mean? Let's figure this out. Do you mean black? Do you mean Hispanic? Then I'll analyze the challenge, right? Here, even after trial, the judge is not sure what he meant. He's not sure what he meant.
Well, counsel, I got it again. So part of the issue that I have with what you're saying is, no one seems to be as confused as you are, because the judge says something to defense lawyer. At least inferentially, we can glean that the defense lawyer knew exactly what the judge was getting at and articulated whatever the reasons were for exercising that peremptory. So although you may not be able to say with crystal clear certainty what the specific issue was that the judge was raising, on this record, there's really no argument at all that defense counsel didn't understand what the judge was getting at and offered whatever it was, a non-discriminatory reason for exercising that right.
So I'm not sure that that's exactly true, Justice George. And the reason for that is trial counsel jumps in with an immediate response, which is, these are my reasons. I don't, and if it were as Your Honor is articulating it, trial counsel would have a duty to object to the trial judge's objection. That seems unwieldy to me. I don't think we should fault trial counsel for just saying, look, I know what I was doing. Let me tell you what I was doing, Judge. And she articulates her reason, and immediately there's no further discussion. The trial judge just says, that's not adequate, that's not it is pretextual, your rights are saved. That's it. He cuts off discussion. There's no opportunity for trial counsel to say, wait a minute, we should discuss this more. So that's what I would say to that. And I would just point out further that the Commonwealth really addresses none of this law that I talk about, where category has to be articulated and has to be articulated correctly.
But I think Chief Justice Budd's original question, though, this is a little different from those other cases where there's a question whether someone is in a protected category or not. And here, it seems like everyone's acting under the assumption that the judge just used sloppy terminology when he started, because everyone, I think, understood that they were black jurors, so they are a protected category, right? Or am I misunderstanding the record on that? Because you're dealing with a different situation, which is someone's challenging, the defense counsel is challenging, you're dealing with the opposite situation where the category is overly broad and the people are actually in different groups. Here, it looks like they are in the protected group, but the judge uses broader terminology than he or she should have, right?
So the judge does use broader terminology, but that doesn't solve the problem of what the record reveals, but also what I was trying to get in Justice Budd's initial question is, so even here, the judge says black, Hispanic. Those are both minorities.
Right.
Let's say we have a black woman juror, right? And the judge says, that's a minority juror, explain yourself, right? Doesn't say black woman. What is trial counsel supposed to direct themselves to? Are they supposed to direct themselves to black?
Trial counsel does, as Justice George just points out, trial counsel doesn't say, Judge, there are different groups here. So they all act on the assumption that we know what the group is, and now we've got to see if there's a legitimate reason.
Right, and I understand that, but unless we're inviting trial counsel to fight with judges about what the category is, I think the category has to be articulated properly. If the court wants to eliminate the first step, as Justice Lowy has suggested, I endorse that wholeheartedly. But under the law, as it stood at the time that my client was tried, you had to follow the law, and this
Attorney
wasn't it.
Nathanson, I think we get that point. Let's
Yep.
move on, just because everybody understands the
Yes.
two positions there. Yep.
So even if we remove the categorical error that we're talking about, there's no pattern here. There's no totality of circumstances that suggests an intent to discriminate. Trial counsel there's a universe of roughly 7 jurors who similarly waffle on whether or not they would be predisposed to believe the allegations. Trial counsel challenges 5 of them. The other 2 that trial counsel doesn't challenge, one was a former intern as a public defender, and the other was someone who said not only would they understand, accept, apply the presumption of innocence, but she went further and offered that she loved the presumption of innocence. So these are the objective, record-based reasons that the court can glean from the record. The court's done that in a number of cases, including Jackson, why counsel would be exercising that kind of challenge. It's very clear here. There's no pattern. So, yeah, I mean, just to get very specific, there's Juror Iverson who says, you know, I don't want to be forced into a black and white. It's a matrix of gray. You know, maybe I would believe, maybe I wouldn't. Trial counsel still challenged that juror. And so that juror was even more favorable than what I think the answers were that Juror Pereira gave. So that's clearly the principle that counsel followed. And so that's the sort of the second, first and second step. When we go to the third step, we look for other factors that might inform the analysis. Is there intentional discrimination going on here? And the other factors also cut in favor of Kozubal. There's no interracial element to the case, such that it's sort of a plus factor, suggesting that one party or another may be trying to move particular jurors off the case for an impermissible reason. There's none of that here. Trial counsel's explanations were prompt, very prompt, clear. They weren't scrambling and shifting. She wasn't running for the...
Counsel, what's our standard of review on that decision?
It's clear error, Your Honor. So this court has said abuse of discretion a number of times, but the Supreme Court has said clear error. And to the extent that there's a difference between the two, I think the court should articulate it as clear error.
Well, what would
Where
you
does
say the
credit-
difference is?
I'm sorry, just one like to...
Or what would you say the difference is?
So abuse of discretion, it used to be quite a bit different until this court's reformulation
But what is the current
in LL.
difference? Just because we're running short on time,
Yes.
what is your position on the difference?
That clear error is essentially, in this case, if there is evidence that suggests that the judge applied the evidence in the record that the judge applied the factors incorrectly, that in itself is clear error.
Where does the credibility determination come in?
So the credibility determination is actually another source of error in this case, because this court has said in Benoit and in a number of other cases, if you're going to make a credibility determination to disallow a strike, then, or actually to allow a strike, you need to be articulating your reasons on the record so that this court can conduct appellate review. There is none here, right? So Benoit says that in that circumstance where the trial judge doesn't articulate the reasons for that third step analysis, then the court will look much closer and make essentially its own determination.
He doesn't say a word about why it's not adequate or why it's not genuine, not a word about that?
Not a word, Your Honor. I'll read it to you. So it's trial volume 4, and the entirety of what the trial judge says is, okay, I find the response to be both pretextual and inadequate. The juror will be seated. Your objection is noted. That's the entirety of what the trial judge said. And so in those circumstances, this court will look closer and make essentially its own determination. So we're running very short, so I do want to try and address the statutory interpretation issue. And so it's a very complicated question.
Well, counsel, let's just drill down to that one. You rely very much on that Facebook case. In this case, the construction as you kind of look at it presumes an integrated list, but it's really not, isn't it? Isn't it a separate list?
No, I don't think so, Your Honor. And there's a number of reasons why, but I think we have to remember the most important part of this is it ambiguous whether it's an integrated list or not, right? And then we apply the rule of lenity and strictly construe the statute in favor of the defendant. But I don't think what we have here is if you mean integrated list in terms of facility, home, or program, all of which are either licensed or funded, then yes, that I agree that in that sense it is a an integrated list, but not in the sense that the last antecedent, which is the rule that the Commonwealth is relying on, suggests that the modifier only goes to, quote unquote, the last antecedent. But that's not what we have here. So the statute in itself purports to define people, right? The beginning of the statute says a mandated reporter is a person who is, and then, so it's a person paid to care for or work with a child in any public or private facility or home or program. If we accept that that comma sets off a separate category of liability after facility, then what we have in the Commonwealth's construction is home is a mandated reporter and program is a mandated reporter.
But why couldn't it be any person paid to care for or work with a child in a home or a program funded, blah, blah, blah?
It could be, Your Honor, but it's not.
I understand that's your position, but why?
Well, so, because we don't read words out of a statute.
Well, I'm reading all the words. I think I have it right here. What word am I reading out?
So, a person paid to care for or work with a child in any public or private facility or home or program.
Yeah, why
funded
isn't
or
it,
licensed.
that's the location of where that person works?
Yes, but it has to be a person, Your Honor.
Yeah, the location where the person works. The person is described by the location where they work.
Well, then I think we agree. So the facility is modified by home or program funded or licensed, right? That's the location. So I think
What is a license under 115D? What are examples that are licensed under 15D?
yeah. So it's section 6 in 15D that really sets it out, and it's a very short list. A school-aged child care program, a child care center, family child care home, large family child care home, placement agency, group care facility, or temporary shelter facility. So it's a discrete list, Your
Could you
Honor.
read the beginning of that list again? Sorry.
I'm sorry.
Could you read the beginning of that list again? Sorry.
Sure. A school-aged child care program, a child care center, a family child care home, a large family child care home, placement agency, group care facility, or temporary shelter facility. But more importantly, I think we have to look at the application of the Commonwealth's interpretation. What does it lead to absurd results? And I think a really concrete example is under the Commonwealth's interpretation, a sales clerk in a children's shoe store is a mandated reporter because they are a person paid to work with children in a private facility. That can't be what the legislature meant, particularly in the context of everything else that's enumerated in the statute. We also have, so it's too broad. There are competing governmental interpretations, which is the DCF regulation, which appears to set off that entire clause as a separate category of liability. In the end, I'm going to wrap up.
Well, actually, if, I'm going to let you in right there,
Yes.
because we've covered, I think, the two things you wanted to cover.
Yes,
And
ma'am.
and I will ask Ms. Cusick to respond to the last argument made by Attorney Nathanson that the reading is too broad and that it would mean that sales clerks would be mandated reporters.
Thank you, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. The Commonwealth is asking this Court to affirm the defendant's convictions for indecent assault and battery on a person under 14 by a mandated reporter. Here, looking at the statute itself, the judge's instruction was correct. The purpose of the mandated reporting statute is the protection of children. It's the overarching purpose of it. Here, there was the comma between facility and or home or program indicating that the language about funding or about licensing.
Counsel, does it cover the clerk selling children's shoes?
No, Your Honor, because a
And
clerk.
why not, under the how do you read the statute so that it doesn't cover the clerk selling children's shoes?
Someone selling children's shoes or someone selling something is not being paid to care for children. They're being paid to sell shoes, assuming this is a for-profit shoe store. They're not being paid to care for children.
But they're working with a child to size the shoe.
Presumably, the child would be accompanied by a parent or somebody who's going to pay for it. But again, sizing somebody for a shoe, I suggest, is different than working with a child.
Because?
Because a child coming in to buy a shoe, it's a brief encounter, presumably. It's not an all-day event. It's not something where you're supervising the child. You're actually selling the shoe. The thrust of that person's purpose is to sell the shoe to the child or whoever is paying for the shoe.
So if you're selling children lollipops, you're not covered.
I would suggest not. You're there, you're selling something. You're not caring for children. You're selling something. The customer.
I understand you're not caring for anybody. I think counsel's point was that you're working with a child, and you're reading a lot into that word work.
I'm
You're reading
suggesting that-
supervision, other things maybe?
No, Your Honor, I'm suggesting that working with a child doesn't mean selling lollipops and your customer happens to be a child. It means something more than just.
But sticking to the children's shoe, I mean, your customer is going to be a child.
It could be an adult with a very small foot, but assuming it is a child, yes. But you're also selling to whoever is paying, who is presumably a person over 18 who has the capacity to pay for the shoe. But I would suggest that fitting a shoe is fundamentally different than working in a public or private facility. It's not even clear that a retail store would be a facility, but assuming that it is, again, selling a shoe is different than caring for a child or being paid to work with a child. And I would suggest that would be an absurd result, to say that any retail store that happens to have merchandise that is attractive to children or that is appropriate for children, that person would turn into a mandated reporter.
Right, I agree with you that would be an absurd result. I'm just trying to work with the words of the statute in the way the Commonwealth suggests we read it.
And I would suggest, again, looking at the purpose of protecting children, again, a child coming into a shoe store is just fundamentally different than a child attending a school.
But if you go to the purpose, now you're butting up against the rule of lenity, right? Because if I have to look at the purpose of the statute and it's not clear, then it does have some vagueness issues. So I'm trying to work with the words of the statute itself and figure out why the clerk is not covered.
Yes, Your Honor. And I would also suggest looking at the statute, looking at the last clause under mandated reporter, there's a Roman numeral 5 down there, and that makes a person in charge of a facility or a public or private institution into a mandated reporter. That's not modified by anything, so it would be the administrator of a school is presumably a mandated reporter, or the administrator of a private facility is presumably a mandated reporter, and there's nothing there suggesting that the legislature intended that this be a broad category, that the people working with children at the private facility are mandated reporters, as are the people in charge of the facility. It doesn't depend on the funding.
How does the statute help you? How does the statute help you figure out where the line is? How about somebody who's working at a carnival? How do you know where the line is from the language?
Your Honor, I would suggest it would go from the person paid to care for or work with children. I would suggest a carnival, you're paid to run an amusement ride, and maybe children come to that amusement park, maybe adults come to it, but I'd suggest that the line is, if it's the essential function of the job to work with children, as opposed to children being incidental to it. So if you're running a carnival ride, children may use the carnival ride, adults may use the carnival ride.
Well, what if the ride had an age limit or a size limit?
If the ride had an age or a size limit, it would still be, I would suggest it would still not be subject to mandated reporting. Again,
Well, I agree with you, that would be an absurd result, but I'm trying to work with the statute. Why, if the ride is designed for children and you are running that ride, and all day, every day, you work with children because those are the only people that can possibly fit into the little seats in this little tiny roller coaster. Why is that not working with children?
Assuming that this little tiny roller coaster is at a larger amusement park that is open to all ages, it would be you're working at a particular area within a larger amusement park, but you're not only caring for children. You're running the ride, but it's open to other people. There are other people there.
So if it was just an amusement park just for the little kids, say in Newton Center, which happens every spring, that would be a mandated reporter, but if it's Six Flags, no?
If it was more akin to a daycare type arrangement where children were dropped off and there happened to be a little amusement park there, it might be that it's subject to mandated reporting because it's more of a caring for children or being paid to work with children.
Right, so, but I'm trying to read out that care for, because there is an or, care for or work with.
Yes, Your Honor. The care for here, running an amusement park ride, that's not caring for children. That's
Right,
running
but
an
why is it not working with children?
Your Honor, because it's working with the amusement park ride, which a child happens to be there, and I'd suggest even if the child happens to be the only person who can fit, again, unless it was part of a larger child care facility or program or facility, it would not be subject to mandated reporting.
I agree with the line you're drawing. I just am not sure I see it in the language.
Your Honor, I'd suggest it's the common sense interpretation of the language here. I'd suggest that this court should read this in a common sense manner and determine that the line is drawn. It's not clerks in shoe stores. It's not people doing things that children might be attracted to. It's people who the essential function is caring for or working with children.
Can I ask, one of the other things we do with statutes is we don't want any, extra language, right? We want to make sure all the sentences make sense, all the clauses make sense. If I read this the way you do, so a public or private school teacher, blankety blank, and person paid to care for or work with a child in any public or private facility, doesn't the rest of this be completely superfluous under your interpretation? Because if all the rest of this is covered by public or private facility, isn't it? So all this stuff about our home or program funded by the Commonwealth, we got 20 more sentences here. Isn't all of this just unnecessary?
No, Your Honor. I'd suggest with respect to home, by making it a home funded, that's publicly funded or licensed, it certainly removes this from.
But that person's working with or caring for a child in a public or private facility, aren't they? So why do we need this language about a home or program?
If the language were not there, it would arguably apply to a private home. So if somebody paid somebody to work with a child in their home, if somebody hired a tutor to work with a child in their home, or a family member, if they paid a grandmother to care for a child in a private home, that would arguably, without that language, it would seem to make the grandmother into a mandated reporter.
Well, but you don't need it because public or private facility, a facility is not a home. So you don't need that. You don't need that. The language you're doing is just, again, it's covered.
Your Honor, I'd suggest a home is different than a facility.
No, but no, you're not. The only homes we're dealing with are homes or a home or program funded by the Commonwealth. No private homes are funded by the Commonwealth, are they?
No, Your Honor, and that would be why I would suggest that the home language it's not superfluous, because it's making it clear that it's particular types of homes, not private homes.
Can I ask you a question about the voir dire issue?
Yes, Your Honor.
You probably want that now. Mr. Nathanson brings up the point that when the experienced trial judge heard the neutral explanation, the judge rejected it out of hand and said.
I'm sorry, Your Honor, I can't hear you.
Yeah, sorry about the math. The judge, who's very experienced, heard the explanation of defense attorney and said, your peremptory challenge is disallowed. What do we do with that with respect to the credibility findings when the basis isn't articulated?
Well, we have an explicit finding of it was not credible, an explicit finding of it was not adequate. And I suggest looking at the record, certainly there's enough here for this court to find that it was not adequate, given that other jurors who had children, such as this juror, I know there was juror 31 and I believe juror 209, both had children. I realized in preparation that I didn't have access to the confidential juror questionnaires. It may be that other jurors had children, and this juror's answer was comparable to that of other jurors who were seated. So
Can you address specifically his argument that more is required of the trial judge?
Yes, I would suggest that more was not required. It would have been desirable to have there be more, but this court can look at the record and discern that there was, that the finding was not an abuse of discretion to say that it was an inadequate explanation, because looking at what other jurors said in response and characteristics of other jurors, this judge, again, he saw the entire veneering when they came in. He saw all the challenges. He saw the parties interacting with the people, the prospective jurors. And if I could address the term minority, I suggest here everyone knew what was being referred to. You can infer it from the record that counsel didn't ask for any clarification or explanation of what the judge meant, and certainly asking the judge to clarify, that would not be fighting with the judge. If the defense didn't think that this was something they should have to explain, they certainly could have suggested as much. So I would suggest here there was nothing wrong with the way the judge conducted the voir dire. Certainly it is imperative to have representative juries, and when the judge saw something that seemed amiss to him, he required an explanation, found it inadequate and pretextual, and seated the juror, and I suggest that that was the correct result here.
Counsel, in response to Justice Gaziano's question, you framed it in terms of an abuse of discretion standard, and your brother, in response to Justice Wendland, said it's a clear error standard relying on the Supreme Court. Who's right?
Your Honor, I believe abuse of discretion is correct, but even if it's not, even if this is looked at as error, harmless error analysis, the result should be the same, that the judge did not err or abuse his discretion when he seated this juror over the defense objection.
But if, to state the obvious, if clear error is more protective, then that's the standard we apply.
I'm sorry, Your Honor.
If clear error is more protective of the defendant, if the federal Constitution is providing more protection, that's the flaw, so that's what we apply.
Yeah, yes, Your Honor, that the standard more favorable to the defendant would be the applicable one if it is indeed the correct standard, but I suggest the result would be the same. And if I could briefly address one other argument, the text messages in this case, I suggest they were all properly admitted. They are voluminous. The Commonwealth did provide the printouts in a supplemental appendix, and there's also a disc that the Commonwealth had moved to have brought before the court, and there is a copy of it that's been brought here which shows the images that were in these text messages that were exchanged, and certainly I would suggest that the messages were all appropriately admitted for all of the reasons cited in the Commonwealth's brief.
Okay. Thank you very much.
Thank you.
Counsel.
We'll take our morning break.
All rise.